I don't know if you saw the news yesterday, but there was a Supreme Court decision that came down that presents a lot of problems. This is the Bostock versus Clayton County, Georgia case. Now, there were some other people involved in the case who have since died, so we won't go into the full name of all the different people, but the essence of this decision is with regard to the Title VII of the 1964 Civil Rights Act, which is a section in the Civil Rights Act that specifies, thankfully, that people cannot be, with regard to jobs, for example, that they cannot be discriminated against on the basis of their race or their sex. Now, there's much more to Title VII, and it's easily available online if you want to read it. I encourage you to do so. And for lo these many years, since 1964, everybody understood that race meant your skin color, your ethnicity, and sex meant whether you are male or female. The dreaded binary that many people now absolutely refuse to acknowledge. And what is the... hey, Kaylin, please get me the list of the different sex options, gender options from Facebook. I mean, at last count, I think it was 54 or 55, something like that. Can you please get me that list? And I'll share that with you. But here's what happened. In a way similar to in 1973 when Roe versus Wade was ruled on by the Supreme Court then, and they fabricated this right to privacy that's not in the Constitution. It's not mentioned in the Constitution. It's not even really alluded to in the Constitution. And the dissenting votes on that ruling in 1973 pointed out that the court actually legislated in favor of abortion being legal across the country and that women have a quote-unquote constitutional right to an abortion, which they do not in actual fact. Now, legally speaking, they do, but in actual fact, nobody has a right to take the life of an innocent person. So there's been this endless turmoil now since that decision because the court in 1973, they added something to the Constitution, or they based their opinion, I should say, on something that's not there, which is the right to privacy, that a woman has a right. You'll notice that if you read the decision, the Roe versus Wade decision, it's not argued the way abortion is argued now, that women have a right to choose, my body, my choice, all of these slogans that people use nowadays. That's not how the majority opinion was framed. It was framed around this belief in a right to privacy. And at the time, this is now lost in the mists of time, but at the time, jurists and constitutional scholars and others who saw with horror that the court had turned in this direction, they pointed out, your whole premise is flawed. Your whole approach to the decision that you took in this particular case is fundamentally flawed. So I offer you that by way of background, because the background is very important to understanding what happened yesterday with the Supreme Court ruling on Bostock versus Clayton County. Now, before I go on, I want to share with you. Now, this is going to help you understand the context of what I'm talking about here. Chances are you've seen on the television news in a local library near you where they've had the drag queen story hour. And you've got men with 5 o'clock shadows dressed as women who are reading storybooks to kids. Just do a quick Google search and you'll see what I'm talking about. It looks like something out of a nightmare. And this is moving steadily in this direction where the very word sex is now being changed, and the Supreme Court has kind of put the final nail in the coffin of this. What once was a word that everybody understood is now being understood differently. Now, before I get to this, I want to give you some background. ABC News has got this list, and thank you for that, Kaylin. This goes back to 2014, so we're now a little over 6 years away from when this was posted. And it was at this time that Facebook had posted or had introduced different gender options. And follow me. I'm leaving a popcorn trail here. Follow me, and you'll understand why this is important. So 6 years ago, Facebook decided that it wasn't sufficient to just say male or female. Here are 58 gender options And this according to ABC News. And Kaylin will post a link to this if you want to see it. So here's the list. Okay, ready? Agender, androgen, androgynous, bigender, cis, cisgender, cis female, cis male, cis man, cis woman, cisgender female, cisgender male, cisgender man, cisgender woman, female to male, FTM. Not sure what the difference is. Gender fluid, gender nonconforming, gender questioning, gender variant, gender queer, intersex, male to female, MTF, neither, neutral, non-binary, other, pangender, trans, trans asterisk, trans female, trans asterisk female, trans male, trans asterisk male, trans man, trans asterisk man, trans person, trans asterisk person, trans woman, trans feminine, transgender, transgender female, transgender male, transgender man, transgender person, transgender woman, transmasculine, transsexual, transsexual female, transsexual male, transsexual man, transsexual person, transsexual woman, and two-spirit. We don't want to leave the two-spirits out. So this is 6 years ago, and Facebook, which you probably spend some time on every day. I'm not knocking you. I'm not attacking you. I'm just saying you inhabit that world, chances are, and you're looking at, people's pictures and catching up with relatives. Just be aware that when you sign up for a Facebook page, as of 6 years ago, these were the 58 flavors that you had to choose from. Now, the list is endless. You can make anything you want and turn it into a gender option that you decide upon. Note, for example, that when people nowadays on social media, when they introduce themselves, you'll see this in the profiles, for example, on Twitter, they will put, blah, 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 and then in parentheses, he, him, or she, her. It's in fashion now to present your required or at least your desired pronouns. Here are my pronouns. Here is how I want you to address me. We talked some years ago about the controversy that erupted with the Target stores. My wife used to love to do the back-to-school shopping at Target, and we would spend a lot of money at Target back in the day. Well, you may remember that Target got itself in hot water because they announced that from now on, all of their restrooms were gender neutral, so that you could go in and, ladies, you might find yourself sitting next to a guy, and there's nothing you can do about it. Now, after they took a beating in the court of public opinion, and their stock price tanked, and there were a lot of, repercussions, which of course I think they tried to brush off and say, well, it had nothing to do with the bathroom situation. It was this, that, and the other. People were boycotting Target, et cetera, et cetera. They finally said, well, we're going to change the bathrooms to just single person bathrooms, but they're still going to be for everybody. And that in itself is okay. I don't have a problem with that. I do, however, have a problem, as I expressed time and time again in those days, of putting, for example, women and children at risk by opening up the bathrooms to men who claim to be women, transgender female, trans feminine, trans woman, you see what I'm saying? All these different things, these are all categories that somebody could say, or whatever other one that they wanted to come up with, to say, this is what I am, this is my sexual identity, this is my gender orientation. Doesn't matter what my chromosomes say, doesn't matter what my physiology says, doesn't matter what my anatomy says, doesn't matter that I've got a 5 o'clock shadow and I weigh 250 pounds and et cetera, et cetera. None of that really matters. In other words, science doesn't matter. This is the epitome of science denial. None of those things matter. All that matters is what I identify as myself. And so I took a stand, and I wasn't the only one. There are plenty of other people who feel like I do. Chances are you do too. To say this is madness because you're putting women and children at risk where you've got something as sensitive as a bathroom. And now you have companies, because they want to virtue signal everybody that look at how enlightened we are, they make these policies that put these people at risk, or high school students, or even younger, junior high school students. Think of locker rooms, showers. I remember being shocked when there was a break in my Catholic school education, because I forget now what it was. We moved, or there's some change in family budget or something, and I went to actually I do remember the circumstances now, but they're irrelevant. The fact is, when I was in a public school setting, I was shocked when we did PE and we all had to pile into the shower room naked. And that was the rule. I mean, it was all boys, obviously. But with the attempts that have been made to change society, they make you and your children at risk. They put you at risk because, let's say, your high school daughter, she is in gym, and now there's a boy who presents himself as a female, and he's not only competing in soccer or lacrosse or tennis or what have you that your daughter participates in, but he now has the freedom to join all the girls in the locker room and take showers with them. You can see the problem here. So this is just a bit of background to explain to you why this is really such a dangerous decision. I would put it right down there with Roe versus Wade and the Dred Scott decision, which essentially was the Supreme Court backing, with the combined might of the federal government and the Supreme Court, backing slavery. Here's how it's being reported in Reuters. The U.S. Supreme Court on Monday delivered a watershed victory for LGBT rights and a defeat for President Donald Trump's administration by ruling that a longstanding federal law barring workplace discrimination protects gay and transgender employees. The landmark 6-3 ruling represented the biggest moment for LGBT rights in the United States since the Supreme Court legalized same-sex marriage nationwide in 2015. 2 conservative justices joined the court's 4 liberals. Now, they really should have put the word conservative in quotation marks. 2 conservative judges joined the court's 4 liberals in the decision. Neil Gorsuch, a 2017 Trump appointee who wrote the ruling, and Chief Justice John Roberts. I'm going to pause there. Do you remember how many times over the last, since we've been observing, since we've been witnessing the turmoil when it comes to a new Supreme Court nominee? First with Judge Gorsuch, and then with Judge Kavanaugh. Judge Kavanaugh, by the way, he voted with the conservative minority on this issue, and we'll get to him in a minute. But remember how I've been saying over and over again, we'll see whether or not these guys are really pro-life, as the case may be. We'll see whether or not they really are, in the case of Gorsuch, a worthy heir to Justice Antonin Scalia, who died suddenly, died in his sleep a few years ago, and Judge Gorsuch was his replacement. And everybody had high hopes, like, yeah, hopefully this guy's going to be another Scalia. No, it turned out not to be another Scalia. And I won't even get started on Chief Justice John Roberts. So much to say there. When we return from this quick timeout, I'm going to take you deeper into this ruling, and I'm going to share with you what some of the specific things are that will inevitably result from this ruling, that will very likely affect you and your family and your children in particular. So please don't leave. I want to talk to you about this. My number is 888-914-9149. I'll be right back with more of this right after this quick timeout.
This is the Patrick Madrid Show on Relevant Radio.
Compelling insights, unpredictable conversations, encouragement for your day. It's the Patrick Madrid Show. Get connected to the conversation. Call now, 888-914-9149. That's 888-914-9149. Patrick Madrid is on now. Relevant Radio.
All right, we're back. I like the fast-paced music because we got to move quickly on this topic. Yesterday, the Supreme Court of the United States, they ruled in favor of the plaintiff in a case that redefined the understanding of Title VII of the 1964 Civil Rights Act. Title VII gets into things about how you can't discriminate on the job, for example, on people. You can't discriminate against people on the basis of their sex or their race. Now, that's just a truncation of what is talked about there, but that's the key point here. So in the ruling, which ruled in favor of Bostock and the other plaintiffs, they redefined the word sex. So I was sharing with you how this is being reported in the mainstream media. So I shared with you some from Reuters, a little bit more on this issue. Workplace bias, they say, against gay and transgender employees had remained legal in much of the country, with 28 U.S. states lacking comprehensive measures against employment discrimination. The ruling in 2 gay rights cases from Georgia and New York and a transgender rights case from Michigan recognizes new worker protections in federal law. The legal fight focused on the definition of sex in Title VII. The court agreed with the plaintiffs that discriminating against gay and transgender workers was inherently based on their sex and consequently was illegal. Now, I need to stop here. The reason this ruling could take place was because they changed the meaning of the word. The meaning of the word sex, as it appears in the 1964 Civil Rights Act, Title VII, does not mean any of the 58 gender options that Facebook allows, does not mean any of the other gender ideology aspects that are currently in vogue right now. It means, and it meant then and it means now, male or female. The binary, male or female. That's what they mean. In other words, you couldn't like go into a potential employer and fill out an application and then get rejected because you're a woman. I'm sorry, we don't hire women. Okay, that is discriminatory. And one of the reasons that it's so unjust is because you have no say in this. It's not like there's an activity that you choose. I'm sorry, we don't hire bowlers here. What? We just don't like people who bowl. I'm sorry. Bowling is not a protected class. If you're a woman, you're in a protected class. If you're a man, you're in a protected class. That's how sex was understood. Same thing with race. I'm sorry, we don't hire your kind here. What do you mean? I'm Mexican. I'm sorry, we don't hire Mexicans. That's discrimination. And I want to emphasize here, lest anybody get a misunderstanding, I absolutely support and will continue to support any legitimate, just effort to end discrimination. I'm glad that we had the Civil Rights Act of 1964. I was 4 years old when it happened. I didn't even know it was happening. We should stand against discrimination. We indeed must stand against discrimination. But when the court changed this word to mean something other than what it did and reinterpreted it now, it opened the doors to a variety of problems. And I'm going to share with you what some of these things are. Now, we're going to post the Reuters story so you can get a sense of how the mainstream media is reporting it. They're very sympathetic to this. I will share with you what Justice Samuel Alito said. He was among the three justices who dissented from this view. So Justice Kavanaugh dissented, and Justice my mind just went blank. I have it on my other paper over here. So Justice Thomas. So Justice Alito, Justice Thomas, and Justice Kavanaugh were the dissenters. And Justice Breyer, Justice Gorsuch, Justice Bader Ginsburg, Justice Kagan, and Justice Sotomayor, along with Chief Justice John Roberts, they were in the majority. They're the ones who voted in favor of this. Now, before I proceed, let me share with you what Archbishop Gomez of Los Angeles said. He issued this statement yesterday, and I'll read it to you. This is in his capacity as the president of the U.S. Conference of Catholic Bishops. And the statement coincides with the release of the ruling. The combination is Bostock versus Clayton County, Georgia, Altitude Express versus Zarda, and RG and GR Harris Funeral Homes versus Equal Opportunity Employment Comment. Now, the reason you're going to hear about this case as Bostock versus Clayton County is because the only surviving plaintiff is Bostock. In any case, Archbishop Gomez says, the justices ruled that the prohibition on sex discrimination in employment on Title VII of the Civil Rights Act of 1964 now prohibits discrimination based on sexual orientation and transgender status. And the word transgender is in quotation marks, as is sexual orientation. So the specific words from Archbishop Gomez are, I am deeply concerned that the U.S. Supreme Court has effectively redefined the legal meaning of sex in our nation's civil rights law. This is an injustice that will have implications in many areas of life. By erasing the beautiful differences and complementary relationship between man and woman, we ignore the glory of God's creation and harm the human family, the first building block of society. Our sex, whether we are male or female, is part of God's plan for creation and for our lives. As Pope Francis has taught with such sensitivity, to live in the truth with God's intended gifts in our lives requires that we receive our bodily and sexual identity with gratitude from our Creator. No one, he says, can find true happiness by pursuing a path that is contrary to God's plan. Every human person is made in the image and likeness of God and, without exception, must be treated with dignity, compassion, and respect. Protecting our neighbors from unjust discrimination does not require redefining human nature. So we'll post a link to Archbishop Gomez's statement. I'm looking at the clock here. I only have a few minutes, and then we're going to go deeper into this when we come back from the break. So let's see. Cyrus, what do you think? Should I take a call or... Okay. Why don't we get to Maria in Illinois before we have to take our break? Hi, Maria.
Hi, Patrick. Thank you so much for taking my call.
You're welcome.
I'm a grandmother, and I have grandchildren, and we're looking at all of this, and I'm thinking, where are our rights? In other words, we're individual people. We don't look at anyone differently. We don't try to be different. We try to do the best that we can within our homes, within our lives. We pray. We try to honor our Lord as much as we can in the best way that we know how. But what I'm thinking now is, with all this thing that is going on, how are our grandchildren supposed to be? How are they supposed to react after everything? That you can't use the workplace. The workplace, one of my children will be going into a workplace, one of my grandchildren. Now, what's going to happen to her when she goes in, and if she says the wrong word, the wrong way, the wrong whatever, where are her rights then?
Well, you can look at it from a couple different perspectives. The people who are in favor of this Supreme Court ruling will tell you that this is, you should celebrate this because this means that everybody's rights are respected. The problem is there's a sleight of hand here by changing the definition of this word sex to include sexual orientation. And I'm going to get into this when we come back from the break, Maria. What it means is that certain rights that you take for granted, like you can go into a bathroom and not have a man sitting in the stall next to you. This will effectively erase that. So certain rights that people have that are as basic as that are being trampled upon in the name of granting rights to people who, because they identify as one of these various flavors of gender identity, that trumps other people's rights, for example, to privacy, the right to safety, and there are other issues as well. So what are your grandchildren supposed to think? Well, if you listen to Reuters and the LA Times and the New York Times and CNN and MSNBC, they're supposed to celebrate this. Problem is, this is one of the really bad decisions in the Supreme Court's checkered history, right down there with Roe versus Wade and the Dred Scott decision. And when I come back, Maria, I'll explain why your grandchildren should look with deep concern on this particular ruling. I'll get to that on the other side. Thank you, Maria. I'll be right back with more right after this. All right, we're talking right now about the Supreme Court decision that came out yesterday. This is Bostock versus Clayton County. It is a reinterpretation of Title VII of the 1964 Civil Rights Act, which by law forbids an employer, for example, from discriminating against people on the basis of their race and sex. These are two of the areas that are addressed in that issue, or in that section. The problem with the ruling yesterday is that the majority view, it reinterpreted the word sex to mean sexual orientation. And so this is being hailed as a landmark civil rights decision on the part of the Supreme Court by those on the left, because they see it as a kind of victory for the rights of transgender people and others who might fit into the gender ideology spectrum in some way. And to some extent, it really is a victory, that's for sure. But it's a victory that was ill-founded, if you ask me, and it creates more problems than it will resolve. And it's not actually, if you ask me, addressing a form of discrimination that the 1964 Civil Rights Act intended to address. So I want to emphasize one more time that I am completely on board with, I completely support the just efforts to eliminate discrimination. I don't want to see anyone being discriminated against. But on the other hand, remember that we do discriminate in many different ways. So we discriminate, for example, against airline pilots who show up to work to drive the airplane drunk. We discriminate. We say, I'm sorry, you can't do that. You're not allowed to get in the airplane and fly 250 people from one place to another. We discriminate against people who maybe want to go into the military, but they don't have the upper body strength to lift the requisite amount of weight when they take their physical. I'm sorry, if you're not strong enough to lift 40 pounds, you don't qualify. We discriminate in many different ways. We discriminate against people who want to be physicians, but they haven't gone to medical school, or they failed medical school, or they have a problem with malpractice. I mean, there are many different things that can happen. Unfortunate, but let's not forget that we discriminate all the time. We discriminate against discrimination. There are people out there who are racists, and we discriminate, rightly so, against them. We say, we do not accept your worldview, that one racial group is inferior to another racial group, whatever that may be. We are always discriminating. We have to discriminate. You discriminate against what food you put into your body. There are certain foods, I'm quite certain, that you won't eat because you don't want to gain weight or you don't want the negative side effects. So you discriminate and you say, that's not good for me. I'm not going to have that. This is good for me. So the word discrimination, first of all, must be contextualized to understand that there are gross forms of discrimination. There are unjust forms of indiscrimination that we should stand against, and we do well to enact laws and to have Supreme Court decisions that reflect our bias against those injustices. And I don't want anyone to think that I'm in favor in some way of denying people justice. It's just exactly the opposite. So because of the way this decision was rendered and the basis of the decision, which is a reinterpretation of the word sex, we got a problem on our hands. This is a hidden meaning, as it's explained by Josh Hammer in the New York Post. He says, this isn't textualism. It's ivory tower liberalism. It's completely at odds with the Supreme Court's longstanding dictum that Congress, for example, in drafting statutes, won't inscribe a hidden meaning in otherwise plain language. As Justice Samuel Alito sharply noted in his dissent, sex in 1964 meant biological sex, man and woman, not orientation, and certainly not subjective gender identity. So this is where these things are going. I want to share with you now some of the ways in which this is going to affect you and your family. And please understand that this is only just the beginning. What we saw with this ruling here is only just the beginning of where things are going to go. So a few things. This is going to affect you and your family when it comes to things like restrooms. So in the issue of discrimination, as it was taken up in this court case, it had to do primarily with employment, but you'll be able to see how this will play out in many different areas. So it's going to give further impetus, I should say, to the companies and schools and government agencies and things that say that you should have complete freedom if you are a boy or man and you identify as a woman to be able to play on sports teams. So women's soccer. If you are into that, my daughter Rebecca is super into women's soccer. Well, you're going to see men playing in women's soccer who identify as women, stronger, faster. What if you have a whole team of men who consider themselves women and they win all the games because they're stronger and faster than the women? Is that fair? Is that just? What about down to the high school level? Your daughter wants to play a high school sport and she's constantly getting destroyed in the track meets and whatever the sport may be because she's competing against a boy who has grown his hair long and identifies as a woman. And so he's winning all these things. And now some people are jumping up and down and saying, you can't say he because he's a transgender female. No, men are not women and women are not men. And it doesn't matter how. Cyrus, get the "This is an Apple" thing for me, please, if you would. Just grab that, if you would, please. CNN, I know you know what I'm talking about. If you could get that, "This is an Apple." I want to play it for you. CNN gave us a great gift when it did this little bit. They thought they were doing something really great, and it kind of backfired on them. Let me know when you have it ready, please, Cyrus. Point being is that whether it's in sports or it's in school, and you have your daughter or your son who wants to play sports and they finish up, they got to go to the shower, they're going to have to shower with people of the opposite sex because this is going to be enforced. Because why? Because it's now considered unconstitutional to do so. Now, there's plenty more I want to get into, but why don't we just take a pause and listen to this brief, I don't know, it's not even 30 seconds. This is something that CNN concocted, and it completely backfired on them because it exposes the silliness of people thinking just because somebody says, I'm a woman, I'm a woman, I'm a woman, means that he's actually a woman. Take a listen.
This is an apple. Some people might try to tell you that it's a banana. They might scream banana, banana, banana over and over and over again. They might put banana in all caps. You might even start to believe that this is a banana. But it's not. This is an apple.
CNN is right for the wrong reasons, but they're right about this. This is an apple. This is a man. And you can put it in all caps and say, this is a woman. You can say it over and over and over again. This is a woman. This is one. Doesn't make it true. But the ruling now is going to put all of these things on their head. Now, there's more I want to get to. I'll just share with you a couple of brief things, and then we'll go to the phones. The number, by the way, is 888-914-9149. PJ Media's got this morning. Tyler O'Neill is the author. He says, on Monday, the U.S. Supreme Court unilaterally redefined sex in federal law to mean sexual orientation and gender identity. In Bostock versus Clayton County, a 6-3 majority ruled that discrimination on the basis of sexual orientation or gender identity violates Title VII's prohibition on sex discrimination. While a technical error has made the ruling inaccessible, the ruling represents an utter rejection of the original meaning of the term sex in federal law, twisting it to mean something Congress cannot have intended in 1964. Justice Neil Gorsuch, long considered an originalist, wrote the court's opinion, with which left-leaning Justices Breyer, Ruth Bader Ginsburg, Elena Kagan, Sonia Sotomayor joined, as well as Chief Justice John Roberts, while Justices Samuel Alito and Clarence Thomas and Brett Kavanaugh dissented. Warning signs about Gorsuch's opinion on LGBT issues emerged in January of 2017. Gorsuch attended St. John's Episcopal Church in Boulder, Colorado. The church's rector, Susan Woodward Springer, attended the Women's March in 2017. Gorsuch served as an usher in that church. The Episcopal Church has shifted hard left in recent years, abandoning the central claims of the Bible on issues like Jesus' bodily resurrection, but also embracing LGBT ideology. This involves rejecting the Bible's clear condemnation of homosexual activity as sinful and its clear statement that God made humans male and female. And if you're wondering, where is that clear statement? It's in Matthew chapter 19, where Jesus is discussing divorce, and he says, in the beginning, God made them male and female, man and woman. This is why a man leaves his family and clings to his wife, and the two become one flesh. And what God has joined together, let no man put asunder. So Jesus gives that definition, that primordial model, the paradigm by God himself for marriage, which is male and female. And if anyone says, well, Jesus never said anything, he sure did. Go to Matthew 19. The following quote may be attributed to Alliance Defending Freedom Vice President of Appellate Advocacy, John Birch. He says, Americans must be able to rely on what the law says, and it is disappointing that a majority of the justices were unwilling to affirm that common sense principle. Redefining the word sex to mean gender identity will create chaos and enormous unfairness for women and girls in athletics, women's shelters, and many other contexts. Pause on this for a second. Imagine you're a battered woman, or you're a single mom, and you and your child are trying to get some respite from a violent boyfriend or violent husband, and you just need a place where you can just rest and get better and get your bearings to figure out what you're going to do next. Well, this ruling would mean that a man who identifies as a woman could move into the women's shelter that you live in. And if it's a dormitory setting, could be in the same room as you and your child, or next door. Do you see the possible implications here? And people say, well, that never happens. It happens all the time. It happens all the time. Women's dressing rooms in department stores. Think of all the times that children have been molested. And these are just the times when people are caught. The depredations, including death, that is inflicted on vulnerable women and children by men who gain access to them in places like bathrooms, changing rooms, etc. Carrie Severino also condemned the ruling. Justice Scalia would be disappointed, she said, that his successor has bungled textualism so badly today for the sake of appealing to college campuses and editorial boards. This was not judging, this was legislating. A brute force attack on our constitutional system, she tweeted. Today, 6 judges acting as advocates opted to rewrite the statute themselves, short-circuiting the legislative process and in the process denying people a decision that should be theirs to make on a major issue. Have no doubts about what happened. This was the hijacking of textualism, meaning, just to insert this, reading the text on its own merits and interpreting it as to what it meant at the time. Have no doubts about what happened today. This was the hijacking of textualism. You can't redefine the meaning of words themselves and still be doing textualism. This is an ominous sign for anyone concerned about the future of representative democracy. Now, let me share with you some excerpts from Justice Alito's dissent from this decision. And this, by the way, is carried by National Review. We'll get a link to this for you. Briefs filed by a wide range of religious groups, Christian, Jewish, and Muslim, expressed deep concern that the position now adopted by the court, quote, and this is from Justice Alito, will trigger open conflict with faith-based employment practices of numerous churches, synagogues, mosques, and other religious institutions. They argue that religious organizations need employees who actually live the faith. So let's pause there. Let's say that and we're going to put the words in quote marks as necessary. Let's say that a transgender woman decides that she wants to be employed at your child's grammar school or at the local parish. And the person says, this is my lifestyle, and you can't stop me from being hired here. You can't discriminate against me. And Father McGillicuddy says, well, we can't hire you because you don't uphold the Catholic teaching on sexual morality. And furthermore, how are we going to explain to our first graders that, this man is dressed like a woman? We don't want to have to do that. It doesn't fit with our deeply held moral principles. I'm sorry, we can't hire you. With this new law, Father McGillicuddy has no choice. With the ruling, I should say, not the law. Father McGillicuddy would have no choice. You see where this can lead to. This problem is perhaps most acute when it comes to the employment of teachers. A school standard for its faculty communicate a particular way of life to its students, and a violation by the faculty of those precepts may undermine the school's moral teaching. Thus, if a religious school teaches that sex outside marriage or sex reassignment procedures are immoral, the message may be lost if the school employs a teacher who is in a same-sex relationship or has undergone or is undergoing sex reassignment. Now, in this article carried in National Review, you see the statements by Justice Alito interspersed with commentary by the author of the article, John McCormick. But there is a link to the entire dissenting opinion if you want to read that verbatim. At least some teachers and applicants for teaching positions may be blocked from recovering on such claims by the ministerial exemption recognized by Hosanna Tabor Evangelical Lutheran Church and School versus EEOC, 2 cases now pending before the Supreme Court that present the question whether teachers who provide religious instruction can be considered to be ministers. But even if teachers with those responsibilities qualify, what about other very visible school employees who may not qualify for the ministerial exception? Provisions of Title VII provide exemptions for certain religious organizations and schools with respect to the employment of individuals of a particular religion to perform work connected with carrying it out. So this gets into the issue of religious liberty in a big, big way, where churches will not be free to say, we're not going to hire somebody who completely undermines, both ideologically and in his own lifestyle or her own lifestyle, the things that we're trying to teach. Their hands will be tied. Healthcare. Healthcare benefits may emerge as an intense battleground under the court's ruling or holding. Transgender employees have brought suit under Title VII to challenge employer-provided health insurance plans that do not cover costly sex reassignment surgery. Similar claims have been brought under the Affordable Care Act, which broadly prohibits sex discrimination in the provision of health care. Such claims present difficult religious liberty issues because some employers and healthcare providers have strong religious objections to sex reassignment procedures, and therefore requiring them to pay for or to perform these procedures will have severe impact on their ability to honor their deeply held religious beliefs. You can see the outline of the religious freedom issue here, religious liberty. Justice Gorsuch wrote in his majority opinion that how, quote, doctrines protecting religious liberty interact with Title VII of the 1964 Civil Rights Act are questions for future cases. Well, you sure bet they are. Separately, the employers fear that complying with Title VII's requirement in cases like ours may require some employers to violate their religious convictions. We are also deeply concerned with preserving the promise of the free exercise of religion enshrined in our Constitution. That guarantee lies at the heart of our pluralistic society. Now, there's religious liberty. There's your personal safety issues. There's the issue of unfair competition. There's the issue of people who may insist upon being employed in places where the things that they stand for are contrary. What if the Supreme Court, to use a parallel, had redefined a term to mean that if somebody was an avowed, I don't know, pick something that you find objectionable. Just to use an analogy, let's pick racism. And if churches or schools or hospitals or what have you were required by a Supreme Court ruling that if somebody is avowedly, this is how they identify as a racist, publicly, KKK, what have you, that is now something that you would have to employ somebody. You could not discriminate against that person, even though you strongly object to that way of living, that way of looking at things. It's a worldview issue. So you would then be in a position where you would have to hire somebody, or at least you couldn't not hire somebody on the basis of that issue. There's a lot here. I want to take some of your phone calls. At the same time, however, I encourage you to read these articles. We're posting them on the show Twitter feed at P. Madrid Show. Let's go to Andrea, who's listening in Maine. Hi, Andrea.
Hi, Patrick. I'm an RN, and this issue, the transgender issue, is kind of become personal in my work environment. But I first want to just start with, RNs are usually very non-discriminatory. We take care of everyone.
Which is good.
But recently, it is good. Recently it's called required documentation when we admit a patient, is a litany of questions regarding transgender, which include asking the person, how they identify, if they've undergone past surgeries, and the like. And personally, I have filled out a couple of them with patients, which usually turns out to be kind of a funny experience because usually it's an 85-year-old woman who we both end up laughing, and maybe we're laughing because it's so absurd. But I guess my beef with it all is that it appears that it's part of our regular documentation, not only to indoctrinate the nurse, but also just every patient that comes into the hospital being subject to these questions that in effect will become just part of...
Can you give me an example of some of the questions?
Some of the questions are you a man or how do you identify as a man or a woman? And I think even the first question is, are you a man or a woman? How do you identify as a man or a woman? And then what if I've never actually had a transgender patient before, so that's another reason why it's kind of absurd. It's just questions after questions of sexual identification. But it's obvious that it just doesn't pertain to most of our population. And so I am very adverse to it because it just doesn't make sense. I think maybe if a transgender were to go into hospital, they themselves make the information known. But I just think it's a way of normalizing the agenda across the board in our society when we have to ask every patient that comes into the hospital all these questions about transgender when they just don't apply.
Right. Well, I can only imagine how nerve-wracking it may be for you in your line of work, because this is expanding. It's becoming more and more robust. And I think what you're dealing with now is just a shadow of what it will become. And decisions like this are going to propel that forward. Let me ask you this, Andrea. If a 15-year-old girl suffering from anorexia nervosa came in, would the questionnaire involve questions like, do you identify as fat or skinny? Would they play into the question of, what she thinks about her appearance, or would you get clinical real quickly?
Well, clinically, as far as
Like
eating habits and
like, honey, you weigh 84 pounds.
Right.
We know she thinks she's fat, but she's not fat. She's wasting away. It would be malpractice, wouldn't it, if you didn't try to help her? It would be malpractice, wouldn't it, if you said, well, okay, if you think you're fat, then we'll go along with that, and we'll operate on that assumption. Right, it would be, wouldn't it? Yeah.
Oh, exactly, yes. When it comes to the transgender agenda, it just seems that it's becoming insidious, and it's being inserted in every echelon of our society. And over time, it's if you repeat something enough, it becomes true.
Yeah.
But we know that's not true. And it's just that same tactic of just hammering it until people give up and they don't question it. So it's happening in healthcare. It's happening to nurses. And I personally, now I refuse to do it. I don't do it. And there are other nurses, too, that say yes. When it comes to that whole transgender piece of our admission, they say, no, I've opted. I just don't do it.
Right. Well, thank you. Hang in there, Andrea. I'm sure it's got to be quite the white-knuckle ride, seeing where this is going. But I'm glad you're listening to the program today. Thank you. We're going to be back with more of your phone calls, and I'm going to read you some selections from Justice Kavanaugh's dissenting opinion on this terrible ruling yesterday. I'll be right back. We're talking about the recent Supreme Court decision, this is yesterday, that redefined the word sex as it was understood since 1964, when the Title VII section of the 1964 Civil Rights Act was enacted. It has been clear that it referred to your identity as male or female. And in the Supreme Court decision that we've been talking about, that was issued yesterday, it's now redefined to mean that it is your sexual orientation. This is Bostock versus Clayton County is the case in question. Now, the dissenting opinion of the three justices who dissented, so that's Justice Kavanaugh, Justice Thomas, and Justice Alito. It's 170. Let me see here. It's 175 pages long. So it's indeed far too long to be able to read to you on the air. We'd have to be here for days. But I do want to read to you a couple of sections from this dissent that will help you make sense of it. Now, we're posting a link to the entire thing so that you can peruse it at your leisure. There's a lot of good information in here, and especially if you have a legal background, it'll make even more sense to you. But here's from the synopsis of the dissent. Reframing the additional causes in today's cases as additional intentions can do no more to insulate the employers from liability. Intentionally burning down a neighbor's house is arson, even if the perpetrator's ultimate intention or motivation is only to improve the view. No less, intentional discrimination based on sex violates Title VII, even if it is intended only as a means to achieving the employer's ultimate goal of discriminating against homosexual or transgender employees. There is simply no escaping the role intent plays here. Just as sex is necessarily a but for cause when an employer discriminates against homosexual or transgender employees, an employer who discriminates on these grounds inescapably intends to rely on sex in its decision-making. Now, this is what is really at stake here. So when you read the section of this decision, and I'm reading to you from the section of the majority here, you see that they're stating that the issue of gender identity is bound up in the question of sex, male or female. But the strange idiosyncrasy here is that gender ideology rejects that as a foundation. That's the craziness of this. That the very premise of there being a gender binary, male and female, is anathema to those who uphold gender ideology, which says that doesn't really matter at all. In which case, if that doesn't really matter at all, this is me speaking here, and somebody says I'm, XX chromosome, I've got all the anatomically correct parts for a male, and everything about me physically, scientifically can be demonstrated to be male, but I identify as a woman, then what becomes of women? What does that even mean anymore? What does it mean to be a woman? What does women's rights mean anymore? Is there any such thing as women's rights? How can there be women's rights? How can there be discrimination against women in the workplace if there is no such thing as a woman? All that really matters is, and all that the court really will recognize is, and all that your employer must recognize is, how you personally feel subjectively about yourself. Do you see the implications? This is like an atom bomb. Because it is destroying the foundation of law on the basis of words and what words mean, they become meaningless. Therefore, to come back to the issue of women, feminism, if you prefer to look at it through that lens, it is now rendered meaningless. It has no more meaning. There is no such thing as women's sports. Because if any man who decides that he wants to compete in women's sports and win because he's stronger and faster, it's just the nature of things for the most part. Men tend to be bigger and stronger and faster, generally speaking, than women. Not all men, but most men. Not all women, but most women. You can see that this is removing this decision, just like the decision, Obergefell, the decision for same-sex marriage. It completely eradicated the meaning of the word marriage. So I do invite you. I have not had a chance to read all 178 pages of the entire ruling, not to mention the dissenting opinions from the three justices that I just mentioned. I would like to read all of this. I just haven't had a chance to digest it. But the link to this is found in the show Twitter feed at PMadridShow. I encourage you to check it out. Let's go to Mary, listening in Lakeland, Minnesota. Hi, Mary.
Hi.
Hi.
I'm just wondering, during this, with this new ruling, how do you think it's going to affect the priesthood and the seminary?
It's another area. What if how about not just priesthood? What about religious sisters? So let's take a particularly jarring example. Let's say that a man who identifies as a woman and has grown out his hair, and he wants to be a religious sister. And they say, I'm sorry, you're not a woman. I mean, there can be many different reasons that a religious congregation would say, no, you're not suitable. But if they say, you're not even a woman, you can't live in a convent with nuns, they would be violating the law as it's currently interpreted. Oh, her phone line dropped. Oh. Sometimes the cell signals don't often work the way we want them to. Let's go to Deacon Tim, listening in Highland, Indiana. Hi, Deacon Tim.
Hi, Patrick. Thanks for talking about this. I have two quick questions. Sure. One, taking your example of the drunk pilot who wouldn't be allowed to fly because he's inebriated, if I can say, I know I look like a man, but I don't feel like a man, can I say, I know I look like I'm drunk, but I don't feel like I'm drunk?
You could say that.
My other question is...
You could say that.
Yeah, you could say, can you get away with it? Well, maybe we'll get away with it. But the other question is, if an institution, a Catholic institution, hires someone based on the fact that they seem like a man or they seem like a woman, and then 6 months later they decide that they're not a man or not a woman, does that Catholic institution have any recourse to say, well, you misrepresented yourself when we hired you, therefore we can release you?
Let's play that out. Let's game that out a few spaces. So the person could say, well, I did feel like a man when you hired me 6 months ago, but I don't feel like that anymore. Now I feel like a woman. So they could respond that way. And then I suppose it would be a matter for the courts if the school said, well, I'm sorry, we hired you as a man, and if you're not going to be a man, then we can't keep you employed. You can see all the crazy ways in which this can play out.
Right. Well, I've also, having been hired by Catholic institutions before, there's usually a clause in your contract that says that you will not do anything or state anything which is contrary to the Catholic faith. Will that part of the contract still hold any water?
The dissenting opinions, this is a great question, Tim, Deacon Tim. The dissenting opinions, the three, are saying exactly that this will change everything, and it will put so many things in jeopardy that were plainly, they were considered obvious and settled, and now it's all unsettled. If the Supreme Court can simply just wave its magic wand and redefine the meaning of a word, presto, anything can happen. And any group can be marginalized, or you see, it's a very dangerous precedent, if you ask me.
Well, I think that the theology of the body by John Paul II is incredibly apropos right now.
Indeed, it sure is. Well, thank you for that, Deacon Tim. Thank you. Let's go to Matt now, listening in California. Hello, Matt.
Hi, how's it going?
What would you like to talk about?
So I'm a law student in California, and I've heard sort of you talk about Gorsuch's recent ruling, or the Supreme Court's recent ruling, and Gorsuch's opinion on it. And you've said a couple of times that his opinion basically changed the definition of the word sex, which I would respectfully disagree with. Having read the whole opinion, as law students do, it
just came out yesterday. I admire you. It's 172 pages. You read all of it?
I did, and I had to take many breaks.
Okay.
But Gorsuch's basic argument is that sexual orientation or discrimination against somebody who is homophobic or considered a transgender within the workplace isn't discrimination based on their sexual orientation, but rather a discrimination based on their sex, because you wouldn't, for instance, a man with a woman, you would never discriminate. To put it in his words, essentially, is that when you're discriminating against a man who is married to or attracted to other men is not something that you would discriminate against if it were a woman. So his argument is that the discrimination isn't that you're discriminating against them based on their sort of preference, but rather you're discriminating against them based on the fact that they are a man or a woman that is attracted to someone of their same sex. So his argument is sort of a little bit more.
But it's not just attraction.
Sex.
It's not mere attraction. In fact, you've read the entire court ruling. I've only read sections of it. But what I have read, it's not merely attraction. It's also how you represent yourself and how you, what you identify as. So transcending the issue of sexual attraction, they're including just simply how you feel about yourself. Now, I'm not a law student. I'm just a guy with a microphone. But if you read, as you did, because you said you did, if you read the three dissenting opinions from Justice Kavanaugh, Justice Thomas, and Justice Alito, you'll see that they, as Supreme Court justices, say this is a terrible ruling because they changed the meaning of the word sex. So their studied judicial opinion, with all due respect to you, their studied judicial opinion is exactly that the majority, they redefined the word sex to make it fit this new paradigm, and that's what they object to. So it's not just me saying that. I'm basing my understanding on these three eminent jurists who are saying exactly that.
Sure, and I would tend to agree with the dissent, but the sort of the way that the dissent has worded their dissent is rather that they fear that this ruling will have the effect of that, not stating that the ruling itself has changed the definition of sex. It's sort of a
Well,
walk a fine
they
legal
say
line
both though.
when they say that.
But they do say
Right,
both
but
though. I mean, they do say on the one hand,
correct.
there are many possible implications that are really bad, but they also say that this is a bad ruling because it's not taking the text on its own, on the face of what it means. It's now changing the meaning. So let's say, for example, that a future Supreme Court ruling defined law student differently from how it's defined now. So law student can be waitresses, the guy who cleans the shoes with spray disinfectant at the bowling alley, the guy who's sleeping behind the dumpster out back behind Denny's. What if they change the legal or the definition of law student to include any number of these other things? And there would be some injustice that could be perpetrated against you who are actually a law student, as the term is understood. Suddenly now, when you have all these other categories who have nothing to do with law studies, they're now included as law students. You can see where this, suddenly anything now can be changed at the whim of the court without legislation. They just rule it and presto, there it is. It's a very dangerous thing, Matt. I don't know if you agree or disagree, but that's how I look at this.
Oh, no, I totally understand where that view comes from. One of the things that Gorsuch did put in towards I think it was maybe the back end of his opinion, was basically he said that this opinion or this ruling does not extend beyond the workplace definition. Mm-hmm. So there is a self-limiter, and I know you were talking about bathrooms and sports earlier, and he actually names that out and says This decision is not meant to prejudge any of those possible topics that we might hear in front of the court. Now, but I think if I can interject, it'll have, it's like a distinction without a difference. It will necessarily have that effect, because all the people have to do who are going to litigate that case is say, look, we just had this case that says it means this. Therefore, if it means this, it's unconstitutional to say that this person can't go into that bathroom, et cetera, et cetera. So it will necessarily involve that, even though they sort of coyly said, well, this is only dealing with this. We don't have to worry about anything else. It's going to inevitably get to those other things, I think. Matt, I'm overdue for a break. I'm overdue for a break. Forgive me, but I would love to talk to you more. Call me back another time, please. I will be right back with more of the Patrick Madrid Show right after this. Hey, Kaylin, I'm, just knowing you as long as I've known you, I guess I've never asked you, did you ever play for the NBA? Ever?
Little known fact about me is, no, I'm just kidding. No, I've never played for the NBA.
You don't seem tall enough to play in the NBA.
I am not tall enough. No, I'm not. But I have a Twitter question about that.
I thought you identified as a 6'8" person.
Which would be short in the NBA. I think you need to be in the 7-foot range.
Yeah.
To be competitive.
I'll do 7'2". Yeah.
Okay.
That's better.
Do you identify as 7'2"? Because I'm not seeing it.
Yeah. I mean, just so that I can play in the NBA.
Oh, I see. Okay.
Yeah. So
I would buy tickets to see that game, Kaylin. I would sit in the front row to watch you play NBA.
Okay. I'd do a dunk just to show off.
So what was the Twitter question?
So this actually came up from @Jet234.
Okay.
And they say, may I now sue the NBA who will not let me be on the team? I am a 50+ 5'1" female who loves basketball. It's feeling discriminatory.
Man, that's discriminatory.
And then I also have a comment from @GloryOfHomeLife who says, Patrick, what's to stop any woman who identifies as a man who applies for seminary to become a Catholic priest? With the new decision, she can't be denied.
And there we have it. Those are both good questions. And they're to the point, because what if down the road a guy says, or a woman who identifies as a man says, when I showed up at the seminary to seek application, they told me, we can't admit you because you're a woman. They didn't say because I had bad grades. They didn't say because I was whatever. They said because I am really a woman and they've discriminated against me. That person could sue the seminary. That person, it leads to all manner of insanity. So those are two good questions, Kaylin. Thank you. And if you ever do decide to play in the NBA, please let us know, because we'd like to hit the pay-per-view on that one.
Yeah,
okay,
of course.
tickets, even better.
Okay.
Thank you. Okay, back to the phones. Let's go to Julie, listening in Madison, Wisconsin. Hi, Julie.
Hi, Patrick. First off, let me say, as one Catholic about another, John Roberts has been a real disappointment for me. The last couple big decisions
Here.
the court has made.
I agree with you.
Oh,
I have a
forgot
theory
to tell
about
you,
why
most
that
people hear
happened. I have a theory. I'm not going to share it, but I have a theory about why he's consistently disappointing. But I'll keep that theory to myself.
Great. You know what? I'm really scared about this, Patrick. Not only, I can see both sides of this. Not only am I a strong Catholic who believes that you're born a boy, it's God's will that you remain a boy till you die. But I'm also a person who's disabled, who years ago when I moved to Madison and I wanted to get a civil service job, I was put on special lists, like affirmative, well, not a, I wasn't going to say affirmative action. I was going to say equal opportunity list. And because of that, I was able to get a state job for 8 years.
Good.
So I'm thinking, what happens? Yeah, it was thankfully because I wasn't a very strong student in school. I had other learning disabilities too. But anyway, getting back to what I'm sitting here paranoid about what people at work might ask me about this. The only thing I can say is, you know what? I'm just here to work, and I wondered if that would be an appropriate response. And what you might have any other responses I might use.
See, you're in a vulnerable situation. Yeah, you need your job. Yeah. So you're not.
And I love my job.
Yeah, and I'm sure you do well at it too. I guess I would answer your question this way, Julie. You're not obligated to fight the culture wars. If especially if you're in a situation, if you open your mouth and say something contrary to what the Twitter mob thinks is correct, that you could lose your job, lose your livelihood, lose your health insurance, etc. So you might feel like saying something, but prudence might dictate that you just don't say anything. That's certainly okay.
Right. Yeah, we had sensitivity training in light of the George Floyd thing. We've had to take empathy and impertinent bias training yesterday. So you see that problem and social media use kind of thing. So they're really clamping down on this kind of thing.
I'm in favor of eliminating anything that we can eliminate that would foster racism. So if sensitivity training for police is helpful in that regard, so we don't see another murder like the murder of George Floyd, I'm in favor of that. So I'm not reflexively opposed to things like training if there's some benefit to it. And I could see where there's a great benefit to that. But it can go too far, and it can go in directions that are, not in touch with the truth. So think about, and maybe you can ask him to pray for you. Think about St. Thomas More, Julie, who during the time of King Henry VIII's departure from the Catholic faith and setting himself up as the so-called head of the so-called Church of England, St. Thomas More was the chancellor. He was like the number 2 man in the realm. And his way of dealing with this was he didn't say anything. He just said nothing. He didn't share his personal convictions until it got to the point where he had to. So silence was his defense. Now, he didn't condone what Henry was doing. In fact, his silence was speaking volumes that he condemned what Henry was doing, but he never actually said it. Now, it got to the point where the king intended to force him to acquiesce to this, and at that point, he couldn't shelter behind silence anymore. So he did say what he felt, and that's when he got his head chopped off. But for the time being, I would encourage you to shelter in place when it comes to this kind of thing for as long as you can. Thank you. Do we have time for another call, Cyrus? What do you think? Okay, let's go to Peter in Texas. Hi, Peter.
Hey, how are you?
I'm well. We have about 90 seconds. Well, 60 seconds now.
Are there provisions in this law that prevents child molesters and convicted rapists from just throwing a dress on?
I haven't been able to read the entire 172 pages, but I don't see anybody bringing that to the fore. So I'm guessing it's probably not mentioned as such. That's all I know at this point, Peter. Thank you. Time for Shelley quickly in Minnesota. Hi, Shelley.
Hi. I want to get some, advice on,
we have 30 seconds.
This total
30
chaos,
seconds.
Total chaos, assault on the church. Do we do we pray? Do we fight? You just kind of said silence, and
Not
how
for
are we
everybody.
supposed to respond?
Yeah, that's a great question, and we're going to be unraveling that as time goes on. Pray for all of us. We all should pray. Some people, like the lady I just spoke to, may be better for them not to speak up and get their head chopped off. Some of us are going to be speaking up in public. I'm trying to do that today. The fundamental thing is speak the truth in love. Speak the truth in love. Sometimes it's difficult to do that, but that's what I think the best advice is that I can give. Thanks, Shelley. I'll be back with more of the Patrick Madrid Show in 21 hours, so please stay right there. I'll be right back. God bless you.
For more of the Patrick Madrid Show, visit relevantradio.com/Patrick.